I am Angelita Blackshear Dalton, and I am the judge who presides in Division 2 of the Davidson County Criminal Court. There are 6 criminal courts in Davidson County in the 20th Judicial District, and we're just numbered by division. I was a former prosecutor, a former assistant DA, and it was work that I really enjoyed doing because I felt that I was doing something to help people in the community. And I realized, after being in the DA's office for I think about 8 years, I think it was, that there was so much more that I could do to help the community, and being in a position as a judge would definitely help me to utilize the skills and talents that I developed in the DA's office. And so when an opportunity presented itself, I ran for a seat in general sessions and was elected, and I'm loving it. All criminal cases, everything from your C misdemeanor disorderly conduct all the way up to first-degree murder, everything in between. Yes, a lot of cases are resolving. Prosecutor's office, the defense bar, they get together as best they can to discuss the cases, to see if there's an ability based upon a certain set of facts and circumstances to try to resolve a case. And we definitely appreciate those opportunities to resolve. Of course, we're there and prepared to try a case if we have to. Tennessee's statutes give the courts authority to order restitution if the circumstances warrant it. Of course, there are some things that we have to look at when determining if we're going to order restitution. Number one, what are the damages? What is it that the victim is seeking? If there are some medical expenses, if there was damage to property. Then we also have to look at a defendant's ability to pay. If we have to set up a payment schedule, we'll do that. What we want to do is make sure that the defendant can in fact pay, because unfortunately sometimes they can't, and the victims may not receive what they're seeking. But we definitely try to make sure that we do what we can to make the victim whole. The chances are, unfortunately, that the victim may not receive the restitution if the defendant is incarcerated as part of the sentence. Just be careful, kind of temper your expectations accordingly. I would encourage a victim in a case to talk with the DA's office, talk with the district attorney to determine whether or not there's going to be a need for that property in the future. Because here is the thing, there could be some issues related on appeal, there may be some post-conviction matters, there are any number of things that can happen in a case. And so we encourage the victims to talk to the district attorney's office and just to get an idea of the disposition of their property and the need for it. So after a conviction, and particularly if there is a conviction after a trial, if a defendant has been found guilty by a jury or even by the court, if it's a bench trial, the defendant has the right to ask what is called for a motion for new trial. Basically, with a motion for new trial, the defendant is claiming that there was something that was legally inappropriately done in a case. So for an example, the judge did not rule properly on an objection, or the judge may have let in evidence that she should not have let in, or disallowed evidence that a party wanted to get in, and so the defendant particularly. And so because of those legal issues, the defendant is entitled to ask or to file a motion for a new trial. When they file that motion for new trial, they're filing it in the same court where the case was tried and in front of that same judge who tried the case. And so that judge is going to I will make a ruling on my own motions, whether or not I got it wrong or whether or not I got it right. If the motion is granted, then the conviction is set aside and you get a new trial. If the motion is denied, then the defendant can file an appeal of the judge's ruling to the Court of Criminal Appeals. a jury trial. The jury could come back on Monday, August 30th. Well, I'm going to set the case probably a few weeks out for sentencing. I have the sentencing hearing, let's say, on September 15th. Well, the judgment becomes final 30 days after the September 15th date, so it'll be mid-October. October 15th, I think there are 30 days in September. October 15th is the deadline to file a motion for new trial. A defendant can post what is called an appeals bond. And just like, when the case is, before someone goes to trial, if they're able to post that bond, they could be on bond while the appeal is pending. So a petition for post-conviction relief is when a person who has been found guilty, who's been convicted of a crime, is asking the court to vacate the conviction based upon some constitutional ground. Now, that's going to be a little different than the motion for new trial, because the motion for new trial is usually some legal basis that they're seeking, like, as I mentioned earlier, as a judge, I ruled incorrectly on an objection, or I allowed some evidence in that shouldn't have come in. Well, a petition for post-conviction relief is for constitutional grounds, and the most common is ineffective assistance of counsel. The Constitution guarantees persons charged with a criminal offense the right to effective assistance of counsel. And so if the defendant alleges that my attorney was not effective in his or her representation of me as a defendant, then I should be entitled to a new trial because it was a violation of my constitutional right. I think that the process of going to court, and this could be for anybody, for the victims, defendants, witnesses, anybody, can be intimidating. And I think that because of the time that it takes, it can be very frustrating, because I think everybody wants finality. Everybody wants it to be over and done and to move on with their lives. And so, yes, as a former prosecutor, I had victims who were frustrated, with the appeals process because of the length of time that it takes. As I remind myself that, yes, I'm a judge, but I'm also a human. I'm a mother, I'm a wife, I'm a daughter, I'm a neighbor, we're as judges, we're allowed to do that. I think sometimes people think that judges have to just kind of be this stoic, this thing, but we're human, and I think that as judges we try to take a lot of things into consideration when we're making our rulings, and provide that empathy.